Next case on our docket today is Hunt versus Hunt. Each party will have 15 minutes to present their arguments. Again, counsel, how long would you like to reserve for rebuttal?
5 minutes, please.
All right, we'll know 5 minutes is reserved. Ma'am, and he'll have his time. He'll speak for up to 10 minutes, and you'll be able to rebut what he has to say. He'll be able to have the final argument for 5 minutes after you're finished. The arguments are being recorded today. When you present your argument, please come up to the podium. Are you able to stand, ma'am?
I am.
Okay,
Yeah,
good.
limited, yeah, but I'm good.
Okay, if you're okay, then thank you.
I am, thank you so much for asking.
When you come up, introduce yourself for the record. Please make sure you speak loud enough so we can hear you. And it's being video recorded, so please stay behind the podium if you would, so that we don't lose you on the video recording. If you have any reason in this case to refer to children or victims, I don't know that you will, or any minors, but if you do, please refer to them by initials rather than their names, if you will. Having said that, we've read your brief and are ready to proceed whenever you are.
Thank you. May it please the court, my name is Attorney David Berta, and I represent the appellant in this matter, William Carl Hunt. This is the second time this case has been before this court. At one point in time, it was remanded back to the trial court to determine or not whether monies paid by my client should be credited towards property settlements and or spousal support. Upon remand, it was also indicated to determine what his interest was in the marital home. Without getting into details about when and where everything was filed, in the sense because it has been before this court, I'll try to get directly to the arguments relating to here today. First argument, Your Honor, is this is a long-term marriage, Your Honors. The court did not reserve jurisdiction. Now you say, well, his spousal support recording really is going to terminate in about 6-7 months. But that not reserved jurisdiction did not allow him or me to go back to the court and say, Your Honor, your incomes were wrong. We think you got to change this. No way to go back and say jurisdiction is still applies, so I can go back and correct that. That is the main crux of that argument. I believe the long-term marriage, and I also indicate with my basis here is that her employment, etc., certainly should have allowed the court to hear that issue over a long period of time. But not reserving jurisdiction, my client was not able whatsoever until today to argue, hey, these numbers might be incorrect. Had that allowed it at that time, it might have been another avenue to file that and say, we think you have the numbers wrong according to the trial testimony, number one, and number two, we can actually supplement that. So I believe, Your Honor, in relationship to that, he could not seek any redress except through appeal. I think a modification of a long-term marriage like that was necessary. I think it was abuse of discretion for the trial court to actually not reserve that jurisdiction.
So counsel, this was a 15-year marriage?
Correct. Correct, Your Honor. That is correct.
And the spousal support was only for 24 months?
Well, it was for 24 months. The original was longer. I think it was remanded to determine the properties distribution. And then that spousal support was cut down to that amount. And that's what the court indicated. It considered what the property distribution was and the amounts paid.
So in this case, because of all the remaining and going back and forth, there's about 5 or 6 years of support. It had already been paid before this entry.
Yes.
Is that fair?
Yes, and I would indicate that that's part of my number two. The trial court committed reversible error and abuse of discretion when it awarded appellee spousal support, both amount and duration. In my brief, which indicates from 2017 to 2022, it was a de facto termination date of 2017, that he had paid over $200,000 towards this case. So the argument is if it's a de facto date of 2017, everything paid from that day forward should go towards spousal support or what the court would award. So in my opinion, you can't have it both ways. Say, well, de facto date's that, however, we're going to start your award now. That was just temporary support. Well, if it's a de facto date, that's when the marriage ended. All that money that the other side gained, the appellee, should be credited to my client because he kept paying it over and over and over and over again.
Well, it seems like the court did that in part, and that this was a 14, 15-year marriage, and as I recall, the order for spousal support after this decree was only for 2 years. So it seemed like there was some kind of, if you will, credit given or time served, if you will, for paying that support previously to the divorce.
In my argument is $200,000 was inappropriate based upon that. He already paid $200,000. I think that should have terminated it right then and there and not continued it on for another 24 months. That is my argument.
Counsel, I was a little confused in the entry. I understand, I don't see anything that says the court is reserving jurisdiction, and I understand the law about specificities about that. There is in the entry, under the, it says, each party, pursuant to the revised code, each party will notify the court and other party of any change in marital status or income until there is no longer a duty to pay spousal support. Seems to cut against the,
It does. I think it still has to be a direct reservation. And in addition to that, my client's income hadn't changed. I think that it's clear that, and you'll see in the trial itself and on the record, the court imputed income at $21,000 when the appellee actually testified that she made $40,000 and then and above that. So if the income did change, I think it would be upon her duty to report to the court that I'd make more than $21,000. She actually, I believe, testified truthfully that she did make more than that.
so was the issue of reservation of jurisdiction ever litigated in the trial court?
Yes, it was also my proposed entry. I also put it on the record. I said, Your Honor, unfortunately, this is one of those areas, I believe that as a practicing lawyer, I think I always have to argue. I think if I don't, I'm risking some malpractice issues in that regard because somebody, it's just the way of the nature of the beast today. People get giant income increases and they lose jobs. It's just a very odd market out there. You no longer can you consider working at a job forever. So, Your Honor, I definitely 100% put it in my proposed entry, and I also argued it in the trial court.
So counsel, if I'm understanding you right, you are saying since your client's income did not change during that 2-year period, there was no grounds to ask for any kind of modification of the temporary support.
My client's income did not change in that 2-year period. That is correct. However, my beef, I should say, to put it in simple terms, is the appellee testified her income was different than what the court found. So they based spousal support on $21,000.
Well, that sounds like an issue for appeal, though.
That's an issue for appeal. Yes, I do mention that.
Yeah, but what I'm saying is originally, the original appeal that came up, that was the same thing, right?
I did present that issue on this court in the original appeal, and actually the court did not address it because it says we have to determine the properly said so. There's property issues before the court determines spousal
It's
support.
premature removed, yeah.
Yes,
Okay, so, but during the pendency of all this was like 4 years, right?
it was.
During the pendency of all this, he did not ask for any type of modification of his temporary support.
He did not. That is correct.
And the reason he had to keep paying was because he actually filed for a stay as well, so that he wouldn't be operating under the 24 months, he'd be operating under temporary support.
Correct. He kept paying that amount with the hope that, obviously, or not the hope, but when upon remand there'd be some credit for that. I believe the court did indicate it, he'd given him credit, as Judge Stevenson said, that for time served, so to say. However, I don't believe, if you look at the amount that was paid, it's exorbitant. And that leads right into my third argument. Well, first of all, my third argument is the court inappropriately determined, actually, it is my third argument, that appellant's interest in the marital real estate was limited to $18,000. Now, he was paying all this amount of time over time, and it was reducing the amount of the loan on the house, so the house became more valuable, but she only determined that his interest was $18,000. So all the time from that time period when it was determined his amount, that his equitable amount, he was still paying down the principal on that mortgage. So either he should get credit for it in spousal support and cross it out, or he should get credit for it in the house itself by paying on the principal mortgage to make it equitable.
Did the temporary orders require him to make those payments?
Temporary orders required him to make the payment. They did.
But you're saying he should have gotten credit, and I think Judge Stevenson is saying maybe the trial court used just a common, and I don't mean to put words in his mouth, but commonsensical type determination and credit, and that was ordinarily she would have gotten more than 24 months of spousal support.
I do understand that argument. However, I'm saying even if we have to look at the de facto date. Does that mean anything? In other words, 2017, I guess that's the real question. I've always had, 30 years now. If that de facto date means anything, Is that the date support starts? Or does the court say, well, that's all temporary, I'm just throwing that away, now it really starts today? But if your marriage wasn't terminated the day of divorce, it was terminated 5 years ago or 4 years ago, that de facto date should mean something. It's just encouraging litigants to continue the case forever, deciding he's getting the windfall. Why would they stop?
You're down to about a minute left in your time.
Okay, thank you.
And let me briefly ask you, was there evidence presented as far as the amount of decrease in the loans based upon the spousal support payments?
There was, and it is in the brief, if you look. And lastly, and then I'll reserve whatever time I have left, it's also reversible error when the figure of $21,008 was used to determine applicable child support due, when the testimony was at least $40,000. So I believe it's hard to put ketchup back in a bottle, but he should get credits for that somehow, somewhere in the distribution of property and or spousal support. Thank you.
Ma'am, when you're ready.
Thank you so much. Apologize, I'm not expert this way, make notes, bear with me. Good morning, Your Honors. May it please the court, my name is Michelle Hunt, and I'm representing myself as the appellee in this matter this morning. I would like to take this opportunity to reiterate that I stand by what was set forth in the brief that I did present to the court. As I'm aware, you've all read the briefs prior to today's hearings, and so I'm not going to stand here and rehash a lot of those and read that to you, but I just would like to touch upon just some additional context or highlight some of the areas that I feel are most important for you to look at today. The first issue raised by the appellant is that the trial court committed the reversible error when it did not reserve the jurisdiction. It was pointed out, but I just want to reiterate that in the brief presented by the appellant, they kept referring to the marriage being 18 years when in actuality it was 15 years, which you admitted. The court, in documents that I reviewed, it seems to have set a precedent that recognizing marriages of long duration tend to be more 20 years or more, which of course this marriage was not. This resulted, as you said, in just 2 years of spousal support. Being a long-term marriage, again, it also just, resulted in a reduced amount as well when it was remanded back and it was reevaluated by the court. There seems to be, from what I could find, no requirement of the trial court to retain jurisdiction in matters related to short-term marriages. The trial court also considered all the factors of the Ohio Revised Code 3105-18C1 and issued spousal support accordingly with a reasonable time frame and provided a termination date. And as you all had mentioned too, there was remedies by which the appellant could have addressed some of those issues, and they did not take those opportunities to address them. Issue number 2 raised by the appellant argues that the trial court committed reversible error and abused its discretion when it awarded the appellee spousal support as to the amount and duration. I'd first like to point out to the court that in the statement, again, you've noticed this and you have mentioned, that in the brief it said that the amount was $22,2073 for 45 months. That in actuality was the original divorce decree from many years ago, but it actually, when it was remanded back to the court after the first appeal, it was reduced to that $1,200 mark with a period of 24 months beginning on 3/1/2023. I think one of the things that's really important to point out in all this is that through all this was temporary orders. These were temporary orders that was initially issued by the court because I was a stay-at-home parent. When I left the marriage, I did not have access to any funds. I did not have access to credit cards. That was all stuff that was controlled by my ex-husband. So the temporary orders were put into place because I did have custody of the children at the time as well, given that there were protection orders for both myself and for them through this process. The trial court is vested with a broad discretion over matters of spousal support. A trial court must consider all the statutory factors for determining spousal support and not base its determination upon any one factor. Although the trial court must consider all those factors that I mentioned set forth in 3105-18C1, it's not required to enumerate each one, but must only provide a sufficient basis supporting the award. That sufficient basis in previous cases before this court has been a statement within the divorce decree that it considered that the judge in the trial court considered all the relevant factors as set forth in that RC 3105 18C1. So if you review the original divorce decree, you can see that on page 19 of that most original divorce decree dated the 2/16/2023, the judge acknowledges and makes a clear statement as part of the decree that there was a complete review of all relevant testimony and application of all necessary factors of that 3105 18C and supporting law, and that the court's findings were based on those factors. Furthermore, the court made a statement on page 21 when addressing spousal support, saying that, quote, said award is based upon relevant factors in the revised code 3105.18, the property sale and temporary support paid during the pendency of this divorce. So it's very clear, the judge mentions this 3 times throughout the divorce decree, that they reviewed all the information, they were following the guidelines of that code, and they did take into consideration all that was presented throughout the trial regarding the temporary support and the payments made therefore.
One thing the appellant says is that you testified at a hearing, I presume, the second one, that you had got back in the workforce and were now making $40,000 a year at that time, is that?
Correct, but that was, if I could, that's in my next statement, if that's okay, and may I address that then?
Please.
Okay, thank you. Let me just finish here. The court again reiterates consideration of all relevant factors and finds that the said spousal support is appropriate and reasonable along with just and equitable circumstances. So again, it clearly took into account all the information provided when making all its determinations. To address your question, so the issue number 3 asks or argues that the trial court committed reversible error when it determined the appellant's interest in the marital estate. I'm sorry, it's in number 4 here.
That's okay.
I apologize.
You're okay.
May I go in order?
You feel free to go in order.
Thank you so much, sir. So with regards to the marital real estate, again, during the initial trial court hearings and the remand hearing, the appellant himself never presented or filed any evaluations relative to the value of the property. I, as the appellee defendant at the time, I was the one that presented, was the only one that brought forth anything regarding the value of the property. So during that remand hearing, it was stipulated, and both parties agreed to the Lorain County Auditor's report presented, which indicated the fair market value of the home as of November of that de facto date of 2017 of $244,210, which is noted on page 12 of the 2023 judgment. Furthermore, the court found credible testimony and documentation to be presented during the trial, which showed a down payment made by myself when I originally purchased the home, because I actually purchased this home well before I had established the relationship with Mr. Hunt and we had ever gotten married. And then there was also a stipulation, it was presented that the home was considered that separate property, so the court did acknowledge that, and that it didn't become joint property until 2005. After the marriage took place, we then jointly took ownership of that property and put a mortgage on that house together at that time, what was left of the mortgage balance. The court found that the property appreciated passively in value from its initial purchase from when I got it in 1998 till we had that 2005 date. The court then gave credit of $25,800 for that passive appreciation through the process. The last figure that the court determined and the appellant stipulated to was the equity in the home as of November 2017, which was $24.23. So all of these figures and numbers were all stipulated throughout the process. They were stipulated to when we had that remand hearing. It was never contested. Nobody ever questioned that. So the figures were just calculated, and that $18,000 was derived based on all that was presented and what the court had accepted and we all stipulated to.
One thing I understand counsel to be saying is, in essence, the value of your loan from the time of 2017 until that date would have gone down some amount of money, and he was paying all that money as ordered by the court. Was there a number ever given to the court where it said your loan went from 160 to 150?
There was not.
Okay.
Nope, there was not. That was never presented by either party at that time. And again, it was looked at, he's arguing that the equity in the home should be included to be paid, but my argument would be that those are temporary orders, and oftentimes those temporary orders are to help sustain while you're going through this process. And then the court gives the credit for that when they evaluate all those factors in that 3105 revised code section. And again, the judge fully accounted and said that that was all, credited, it was all taken into consideration. I'll finally get to your question here. So the final assignment of the error was presented by the appellant was that the trial court committed a reversible error when it used the figure of the $21,000 when it determined the applicable child support due from the appellant to the appellee. Well, I presented arguments regarding this in the brief. To be honest, there's kind of two factors here for me. And I think they're important here to point out. To me, it's almost a moot point that we're arguing about the child support, because in reality, this case had gone on for so long, and with the appeals and then with the stay put in place, the appellant never paid child support for the oldest child. By the time we were going through that process, he turned 18, graduated from high school, and now, that was no longer, there were no payments made on his behalf. And then we're going through the second appeal process. So I get a divorce decree that's issued February of 2023. I have a son at that point, the second child, who has already turned 18. He's graduating in 2.5 months. So I ultimately received 2.5 months child support for that child. So again, you have to take into consideration when you're looking at those temporary orders, there was no child support received during that time. There was no spousal support during that time, which had there been, that duration would have been much longer, and those numbers would have been much higher probably in all reality when you look at it than what was provided in the temporary support.
Does he still owe you child support arrears for never paying that temporary, or does the court?
There was nothing giving in arrears. It was all, from the February 23 forward. That's why I said it was 2.5 payments. So the matter has been, so the other thing, this answers your question, to the extent that the appellee cites financial information obtained, that information was obtained during the hearing from the remand. It's the remand hearing that we had that took place in July of 2022 and supported his argument that the mother's income used for child support calculations was incorrect. But my argument is that that evidence falls out well outside that date range of what the trial court used when they calculated his income. So they used his income based on the information that was provided from 2017 to 2019. During that remand hearing, I apologize, during that remand hearing, nobody questioned, nobody brought forth any information, the judge never asked, there was nothing inquired as far as his current income. So when they did all those calculations, they were looking at his income from 2017 to 2019. So I believe that what the judge did when I looked at all the numbers is they're looking then at the same income for me during that same time frame. Does that answer your question?
It doesn't part, but I just want to say, understand is what appellant says is true. At that hearing, you did testify, yes, I got back to work for it now, I'm making $40,000 now.
Right.
That's what you were earning at that point in time.
Right. So if there is some kind of error with that for those 2.5 payments, then there needs to be some kind of clarification on what the appellant was making at that time frame as well. Which in all actuality, it also showed throughout the trial that his income fluctuated greatly and it continued to increase. There's even a notation at one point that the court was looking at $130,000 salary. He's in sales, he gets quite a bit of commission, and since then he has been promoted significantly. So this matter's been ongoing, as you know, for 7 years, and I'm at the mercy of this court today to find relief, put an end to what we've been going through. This doesn't impact just me, but I have 2 children that have been, very deeply invested in this process as well. And we're just very much grateful to have this opportunity to present to you today. And if you have any other questions.
See none, thank you.
Thank you so much, really.
Thank you. You'll note in the record, in the actual court file, some additional filings by my client after the actual hearing showing that the mortgage has been paid as an update. The problem in this case is, and it can't be overlooked, is the amount of time this took. I would like to say that, I don't know how you can enforce it otherwise. I know the Supreme Court has guidelines, but the attorneys are often at the mercy of the courts for those guidelines. So in the meantime, sometimes inequity happens. And that this is a such case. Because of all that time, all those stays, all the remands, Con kept paying, he's like, what do I do? And he just kept paying what order.
But I want to clarify though, he's the one that asked for the stays.
I'm sorry?
He asked for the stays, he could have appealed without asking for the stay, right?
He did continue to pay, though, is what I'm indicating. The court, and the record's clear, I think that was clear on the remand, he paid. He continued to pay all those payments.
So he had a stay for the spousal support, but I'm not sure he had a stay for the child support.
No, he wouldn't have child support stay, of course, no, absolutely not.
Okay.
However, and I think it was more than 2 months, and I don't want to speak out of turn. I thought it was more like a year that's child support, but there were definitely, I think it was conceded that that was an error in the sense that they used the wrong figures. Now, appellee could have appealed the fact that the court used the wrong income of the appellant, if she wanted to, but that's not before this court. He testified as to what it was, that's what the court found. Appellee did not appeal that portion.
You agree that your client paid the child support, there's no arrears we're talking about here?
I agree. He paid the child support, there's no arrears, there may be some overpayment, and
Have to be settled up at some point in time, but certainly there's no arrears.
it's a nice thought pattern that it'll be settled up at some point in time. Good luck on that one, in my experience, and that's why I think because there's still some issues that are unfortunately go back to the trial court because the sale or refinancing had to be done well in advance of today by the appellee, and it hasn't been done. So unfortunately, we're going to be back again for the court. I hope we clear it up. But
I have one more question, if you don't care, in regard to the child support. It was 2.5 months or so. It was 2.5 months or so,
yes,
and he did pay it. Why is the issue not moved now?
the figures were, I believe, what was his option? Was he say, I'm not paying it because the figures are wrong? I think he'd be in arrears, he wouldn't have a driver's license. So I mean, he's kind of at that liberty, he paid it, and I think the way the CSEA always settles it up later. I know overpayments throughout the history of it, you go to CSA, say there's an overpayment, they go, well, wait till the kid's 18, we'll figure it out, and then you might be owed money. Then they go, well, you're not withholding money in escrow. They go, no, you just have to pursue it, you can get a judgment against them. So that's the problem. It's not a perfect system. I mean, I think every one of us would change it if we could in some ways. However, it is what it is, and the fact pattern is I appreciate the trial court having a lot of numbers thrown at it. There are a lot of numbers. My numbers are in the brief as to what I think the equity is. Not arguing what the value of that house was. We agree. It is what it is. It's a matter of how the trial court divided that up. And at what point does his duty stop to keep paying? Thank you.
The court will take the matter under advisement and will issue a decision in due course. And that decision is briefly mailed to you by the clerk of courts and also be available on the High Supreme Court website. With that, on behalf of the court, I'd like to thank both of you for your presentations.
Thank you very much.